The content of the following program, including all statements from the hosts and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by the host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program shall not be viewed as substitute for a personal consultation with an attorney. Now, prepare yourself to be informed and entertained by Gus Bravo and Neil Kotze, two AV-rated trial lawyers who have been practicing law for a combined total of nearly 40 years. For the next 30 minutes, they will share their insight and commentary on important legal issues affecting all of us.
A 28-year-old lawyer is in a car with a friend of his who happens to be 25, and they're driving down the road and get involved in a terrible car accident, and unfortunately, both of them pass away in the accident. So they arrive at the pearly gates of heaven, and yes, the lawyer actually did make it to those pearly gates, and the two of them are standing there, and St. Peter looks at the 25-year-old friend first and says, our records show that you're only 25 years old, and we have a new policy here which we're going to immediately send you back for reincarnation because you've not lived a full life. And poof, the 25-year-old disappears. Well, the 28-year-old lawyer, looking at St. Peter, immediately says, well, I'm only 28, so I assume you're going to do the same thing for me. Thank you. I can't wait to get back on Earth. And St. Peter looks at his records, and he picks up the document in front of him and says, 28. According to your billable hours, you have to be at least 83. I'm Neil Kotze. With me is Gus Bravo. Welcome to Attorney Confidential with Gus and Neil. Yes, I did it again.
I'm going to go on a boycott here. This absolutely sets me up for the rest of the show. For those of you that don't know me, my OCD is very strong, so I need a certain level
That's why I do it intentionally,
of symmetry.
to throw you off. It's a lawyer trick.
Anyways, welcome to Attorney Confidential with Gus and Neil. First of all, Neil, I wanted to thank you, plug the Rotary. We had a wonderful time on Friday at the golf tournament at the Miami Shores. My buddy and I, we got to work hard for 4.5, 5 hours and enjoy the fruits of our labor afterwards. So a wonderful event
I'm
you guys
glad
put
you
together.
did. I mean, for those of you that are familiar with Rotary, it's one of the world's leading service organizations, and we had our golf tournament at Miami Shores this week, and I'm glad that you had a good time, Gus.
Yeah, listen, we started drinking at 9 o'clock in the morning because you guys made it so early.
And the other thing,
5 o'clock somewhere.
I don't know, Gus, can I tell them your score?
We shot even par.
That's true. They shot even par. The winning team came in at 53, which was 18 shots under par.
Well, listen, those guys there were two, let's just say, gentlemen more advanced in age, and then two kids who clearly just got their driver's license. So the one kid was the long hitter, and the other one was the short player.
Right.
And then the old guys were, I guess, just keeping score. I mean, kudos to them. They set up a good team, but we're very happy. And listen, we had a fun time.
Good. I'm glad.
Look, I just wanted to, before we get to the substance of our show, not that there's much substance, but I just got this headline. Go ahead. Headline on ESPN. Actually, it's Miami Herald. The NFL suspended Super Bowl MVP Tom Brady for the first 4 games on Monday, and has fined the Patriots $1 million.
Wow.
For Deflategate. But this is the most, that to me was the most interesting part of that story. The 2 equipment managers who were involved in the so-called the deflators have been suspended indefinitely. I mean, come on, really?
Really?
Brady 4 games.
You're gonna penalize the guys that God knows what little they probably make as equipment managers, and let Brady get away with that?
Yeah, indefinitely. What, are they going to revisit in 6 months and see? I mean, get replacement equipment managers? Look, I'm a long-suffering Dolphin fan, so I can rejoice a little bit in New England having some struggles, but that's just ridiculous. And suspending Brady just for 4 games.
That is sad.
He should be suspended for life, as far as I'm concerned.
Right.
Tom Brady, if you're looking at me, I know you're one of our listeners and viewers.
Well, I mean, if he had a role in it, you got to penalize who had the role. I mean, it's just a classic example of just not punishing the people who should be punished and blaming. It's not whether, a lawyer, a friend of mine that taught me how to try cases many, many years ago, once said to me, it's not whether you win or lose, it's how you place the blame.
So, speaking of placing blame,
right?
I know last week I thought a little bit, as prognosticators, we posed the question of the Mayweather Pacquiao fight
as a joke.
And we thought, who would be foolish enough? Well, not foolish enough, but we didn't think that there would be a cause of action. But
humor has its elements in reality. There have been several class actions actually filed. Our example last week, though, to our defense, was an individual who had a complaint that they didn't like the fight. And I still would stand by that's probably not a reason to file a lawsuit. What we didn't know on last Monday's show was the Pacquiao shoulder issue. That he actually, prior to the fight, knew he had a shoulder issue, had signed medical release forms indicating he was completely healthy, had no injury. I mean, it's one thing if you had a little tummy ache, but when a boxer has an injury in their shoulder, I had a shoulder injury once and I couldn't hit a golf ball straight.
But I don't think that was a shoulder.
Well, it wasn't. I mean, that's just that was the excuse I used to play with me. Yeah, well, I can't have, it was just a little more of a hook. I was a hooker. Well,
I don't know where I go with it. I'm going to move on.
Right, exactly. But the thing is that if you have a shoulder injury and you know you're going into a fight and you know you have an injury that's going to require surgery, think of all the people that have suffered as a result of that. You've got the gamblers in Vegas and a good friend of mine, I think one of the better, if not best, plaintiffs law firms in South Florida, Kelly Ustall, a good friend of mine, Jordan Lewis, who's just a phenomenal class action lawyer, has actually filed one of the lead class action lawsuits claiming that they breached the contract that they had. Pacquiao signed a contract that he had no injury, and therefore all the people who viewed that fight are what we call in the law third-party beneficiaries. And I won't go into that in any more detail.
Our listenership just dropped by 40%. Listen, you sounded way too smart for this.
Right.
The problem is this: is that people spend $100. Okay, and it was being billed as the fight of the century. I think we had a picture up available on Pacquiao Mayweather that we got.
You may still have one that you were going to show.
from Google Images that wasn't licensed and properly licensed and whatnot. But there he is.
There's the fight for those of you watching on TV.
Yes, all 10 of you.
Right.
And it's not TV; it's now the internet.
That worldwide interweb thing that people log into.
We're not on a channel, Neil. I mean, so it's not going to be television. I'm sorry to tell you that.
I aspire to be on television.
I mean, I guess if you have,
I was told I have
TV,
a face for radio, but I aspire to be on television nonetheless.
I don't know who said that to you, but the problem was this. So this was billed as the fight of the century. Oh, for which century? I guess But you could
we're only 15 years into the century, but I guess that's okay.
Well,
it's easier to bill it that way.
Or the millennium.
Right.
And so they oversold it. But the problem is when you're paying for that package, you're paying for the experience, right? You're paying for the fight, the event. The gamblers, I think, especially in Vegas where it's legal, may have a stronger leg to stand on because they were just betting on the outcome. The outcome was everything. Whereas the guy who pays, or gal, who pays all that money to go fly to Vegas, you have Jay-Z with Beyonce, all these celebrities, they're going there for the experience. They don't know anything about boxing anyways. So for them to sort of now start complaining that they didn't get the benefit of their bargain, I don't know.
It's an interesting claim, but never, as I always say, never underestimate the creativity of a good plaintiff's lawyer. And so there are claims being filed all around the country on this issue, and it'll be interesting to see how it progresses. I mean, one of the things that let us talk about is class actions. Gus and I, you are talking about class actions and the history of them. Class actions have really taken on a life of their own in the last several years. They originally were developed to benefit those people who were really harmed in such a small way that they would never find a lawyer to take on their case.
I think I read that on Wikipedia.
Wikipedia, where we do all our legal research other than Westlaw. Yeah.
Just for those of you who are listening, I read it out. He's got a Wikipedia class action here.
It was a quick summary. I know a lot of this stuff, but it was a good quick summary to refresh my recollection.
I will say this, Wikipedia is an excellent
and there are a lot of, I could walk through, I highlighted a lot of inaccuracies. I mean, I've been involved in
You can actually go in there and correct that.
That's true.
So you should. But you were saying, I'm sorry, the origins of class actions. Well, the origins
of class actions. I mean, the best example I've used in clients that I've had class actions with is, it's back in the day, let's say a phone company, let's say Father Bell, is overbilling each one of their customers a penny a month. Well,
which
would never happen. But if they had a practice where they actually added a penny to everybody's bill. Now, you've got millions, hundreds of millions of potential customers. That penny a month could be millions of dollars a month they're profiting, but for each individual involved, it's only a penny. Who's going to sue over a penny other than a lawyer? So, I could also make some ethnic jokes now, which I'm gonna go there.
No,
but anyway,
no.
well, it would be self-deprecating humor.
but still.
But for that penny, what happens is class actions are designed to help those people who've been damaged, even if it's, and a penny's the egregious example. Lawyers like to, by the way, if you haven't figured out already, use those egregious examples all the way to one degree or the other degree.
Right.
Nobody's really filed too many class actions over a penny. But
that's the logic behind it.
Exactly.
Right?
And it
Where
protects,
you have individual claims that are on their own. A consumer may not be motivated because of the lack of, they're not going to get their attorney's fees recovered, or the amount of damages are so small it doesn't justify going through the expense and the trouble to hiring a lawyer. Well, collectively as a whole group, yes, now it makes sense because obviously you'll have lawyers interested in taking a case on behalf of the masses.
Right. I mean, it's a classic example of what a terrible pun. A classic example of that incentive, because let's take my example of the case where let's say there's 100 million customers, and to use simple math, a penny would be exactly $1 million a month. That case is worth.
I'm glad you made that math, not me.
Well, that would be a $12 million a year case. Now, what the lawyer is looking at a 40% recovery rate. I mean, you do the math.
That's a lot of money.
Even at 1 month's worth of damages, right. You're looking at a lawyer recovering $400,000.
So the source of class actions, or maybe the purpose behind it, was to create a system where the Davids can get all together and go after the Goliath.
Right.
Would that be fair? And I don't know, was this Pacquiao Mayweather brought as a class?
Yes, it's going to be brought as a class, and I don't know how many people were watching. The interesting thing about classes, and we can go through this in meticulous nature, which I don't think we will, obviously.
No, we'll lose those five that are still
but there's a lot of requirements, and so you can't have a class action of everyone that was involved in the fight. They would all have to share a very unique circumstance or a very similar.
So only people that ordered on pay-per-view.
Yes, but if there were different pay-per-view stations charging different amounts, you might have to everybody.
I believe there was Showtime and HBO, because these guys couldn't.
So the Showtime and HBO may not be able to join. All the Showtime may have to be one class, and all the HBO another, depending on that contractual relationship. The class is my example. If everybody that has this phone company is being overcharged a penny, they're all the same. But for example, some class actions, even though people have similar damages, they're different enough that it's not appropriate for class certification, which is the process we undergo in class process.
Now, but is the class action that your friend Kelly Usaw is taking on, is that on behalf of the pay-per-view?
I believe that's the pay-per-view, yeah.
Now, there's a group of folks that attended the event.
Right.
Obviously, I feel less bad about those folks, because, I mean, they had the money to fly out to Vegas. We know somebody that
a good friend of ours, where he paid $2,500 for his ticket. And he was in the bleachers, I think.
Dan, if you're listening, I don't feel bad at all that you spent all that money. So, I'm not, and no one's going to cry over that. But those folks would fall into a different category.
Exactly.
Right? Now, what do you think? What would be the biggest hurdle that they would have to overcome? I'm going to put you on the spot.
The biggest hurdle that the pay-per-view? You're going to have to show that they truly were damaged, that the expectations were lowered by that much. I mean, they're going to have to show the damages. I think showing liability might not be as much of a problem. It's how much were they truly damaged. And we can go into that a little bit later, but now we're at the break point, I think. So.
Well, we're coming up on the half hour, not half hour, midway point break.
The half hour.
The half.
Again, my skills math at the half hour.
That's why I went to law school. But the first half, we've been talking about just class actions in general. I think the second half, we're going to get into the slippery slope of what if you allow these types of cases in class actions, especially sport events, to go to their logical end.
Yeah.
So you're listening to Attorney Confidential with Gus and Neil.
Attorney Confidential with Gus and Neil is being brought to you by the law offices of Neil D. Codsing and Bravo Law. Bravo Law is a business litigation firm known for providing common sense solutions to small businesses and individuals throughout South Florida. Mr. Bravo is rated AV by Martindale Hubble and Superb by ABVO. the highest ratings available from these two entities. The law offices of Neil D. Kotze is a litigation boutique with offices in Broward and Miami-Dade counties. Mr. Kotze is a veteran trial lawyer with nearly 25 years of jury trial experience. He is also a two-time recipient of the South Florida Daily Business Review's Most Effective Lawyer Award, a recipient of numerous awards for providing pro bono legal services, and has been recognized by the National Law Council. Call our office, 786-464-0841 or 954-790-6711, and get informed. You're listening to Attorney Confidential with Gus and Neil. If you have a comment, question, or just want to contribute to the conversation, call the show at 888-565-1470 and share your thoughts on what's going on. Now, back to Gus and Neil for more Attorney Confidential.
And we're back with Attorney Confidential with Gus and Neil. We're topicing today. I don't know if we have a topic per se. We're talking about class actions. We've been talking about the Mayweather-Pacquiao fight and just the effect of the new class action that they fought. And we're going to get into the slippery slope of if we allow those types of cases or allow those arguments to be advanced, what are the effects?
Right.
But we actually have a caller on the line. For those of you who want to call in, it's 888-565-1470. And Michael, you're on with Attorney Confidential with Gus and Neil. Go ahead, Michael. Michael, you there? Okay, it looks like we lost Michael. We might be batting 0 for 2. By the way, there was a caller we had before, and I don't know if I told you this, that was actually my 12-year-old son, so I'm going to rat him out. So it might be Michael doing that, or maybe you're the one that's calling.
No, I haven't set up any calls.
Okay. So anyways, if you want to call in, 888-565-1470. Look, here's my problem that I have with this Mayweather-Pacquiao. Okay, so the folks that pay to whether pay-per-view or to attend or whatever, it's a sporting event. Unhappy with the product, right? Unhappy with the outcome. I'm happy with the services. But where do you draw the line? So if I go and pay to go to a Dolphin game and the quarterback is playing hurt, right, or is less than 100%, am I then entitled to bring a similar type of claim against the Dolphins? I would love to for the past 15 years of misery that they put us through, but I'm not sure that's where this is going, where we want to go.
Right. I think that the problem you run into is, again, what are the damages? It's not the liability as much, because with the Pacquiao issue, if Pacquiao truly did lie to the for the medical exam and say that his shoulder was okay, knowing that he was going to have to undergo surgery, he falsely filled out a form and breached his contract. But who's going to rely on that?
Who's going to rely? Who's relying on that?
Well,
you're saying
because I believe the terms. I haven't looked at the contract myself, but I believe the terms of the contract would be that we have Miguel on the line, so we're going to get to him in a second. But I believe the terms of the contract required him to disclose that, and they might have canceled the fight if he had an injury. So that's where we get to the benefits that people watching would have known that and not paid their $100. But I think we've got Miguel on the phone. Miguel, are you there?
Yeah, this is. I'm thinking the latency. I'm sorry. What do you think? The internet is guilty of a lot of latency, and you're up to date. I think that's good. I wanted to compliment you.
Okay. I think you're referring to, it's hard to hear, but the internet with the fight. And I don't know if I misunderstood it. Neil, did you pick it up?
No,
or
I
not?
didn't.
We'll create our own question. We'll deduce from what you said.
It's not really new news.
I'm sorry?
It's latency. It's old news. You're right on the ball. I wanted to question you about that. Whether case law is really for today. I don't know. I don't think so. I doubt it.
Neil, you're the class action expert. If you want to turn to your Wikipedia thing, I'm not sure you're going to find the answer to that. Miguel, thank you for the call. We appreciate the kind words. And I think what we'll do is, look, let me rephrase it. I think there's a lot of, I'm not sure if there's any precedent, right? When we talk about precedent, we talk about other cases that are similar like this, that maybe that can set an example or a guide of what could happen.
Yeah, I mean, there aren't any that come to mind as far as the sports issue. I think that what you have is anytime you've got a breach of a contract where someone makes a statement and there are people that rely on that, it depends on how many people are affected by that breach. And I think the creative nature of the lawsuit filed by Kelly Eustall is that it goes to the whole third-party beneficiary thing.
You've given him 3 plugs now,
I know.
and third-party beneficiary.
Right, it's the only way I know to describe it. It's the legal doctrine.
I'm sorry. Here's the way I look at it is this particular fight presented almost the perfect storm, because it was the only way you could get access to it was paying for the fight on either Showtime or HBO, or attending. Right. A lot of our sporting events, it's on, I guess you want to call it free TV. I mean, we all pay for it, but it was billed at such a high, sort of promotional level, like any fight is, and like you said, look, a fighter that cannot throw punches. Right. I mean, it's a very critical thing, and you're in there in the ring with. That's it. It's you against the other guy. And my team example, well, we can put in another quarterback. We can put in another player.
Oh, yeah. I mean, the example, I'll ridicule my own team, the Tar Heels, back in the day with the late, great Dean Smith and Four Corners. You imagine how many lawsuits would have been filed, how boring those games were when they went to Four Corners?
If you don't get the expectation is what I'm getting at. I get it.
Which I guess goes to the latency point, since I'm talking about basketball that was played in the 70s. But nonetheless.
I'm not sure that's where it was. But look, my concern is, where do we draw the line? Okay?
Right.
Then, go from sports to entertainment. So let's say you go, I know you like to take your wife to the plays and opera and whatnot.
Here's the issue, though. The fact that it's a class action isn't any, you have to think of it, does one person have a legitimate case to file? Then you decide whether it could be filed as a class. The Pacquiao issue is, does any one person who watched that fight with the understanding that the fighters have to sign an agreement that they don't have injury, and that person feels that they suffered damages because they wouldn't have otherwise paid their $100, is an individual case, one person against Pacquiao or whoever the promoters are. Then, if that one person has a legitimate legal theory, then you decide whether it's appropriate for a class.
You know what?
Class action doesn't change the law.
Mayweather and Pacquiao should try the mea culpa approach. The I'm sorry. The come out and listen, have another fight. Everyone who bought a ticket to the first fight, you get your admission paid for the second fight, or at least at face value, or a greatly reduced price. Same thing for anyone who bought it on pay-per-view. You get a big discount and give us a do-over. I mean, I think that's the solution. It's the mea culpa. Maybe legally, that's probably not the right smart move, but again, that may cut off a lot of the negative publicity, because I think what people feel at the end of the day, they feel cheated, and when folks feel cheated, that's when they come to lawyers and say, "What can I do about it?" Right.
But the best they're going to get is their $100 back, and if this is a legitimate case and you have a lot of people, then the lawyers will get some money out of it. But having not seen the contract at issue, and this was filed as a breach of contract, it's hard to really evaluate the legitimacy of the claim.
No one's listening, and no one's going to hold you to what opinion you give.
Exactly.
To give me the legal disclaimer. Once I read the contract on it, we know those were littered with all sorts of exclusions and exceptions and what. I'll be curious to see how this turns out. I think it's a very creative thing. I think if there was a time for someone to challenge the professional sports in general, there's a time to do it. And again, I go back to what I said at the beginning.
It's one of the most interesting set of facts. I mean, I don't think you're going to see too many cases like this, but because you have someone who basically lied about their injury. I mean, that's why, you and I have talked about this. That's why you get in the paper, you get the injury reports before games.
I wonder why.
It's because of the gamblers.
Absolutely. And the stats. The fantasy sports.
But what's a little bit different about that, which is different from boxing, which is going to play out a little bit, is boxing is win, lose, or draw. So whether someone has an injury or not doesn't necessarily dictate who you're going to bet for, because you might think even if they were healthy, they weren't going to win.
Yeah,
but with a football game, you have a point spread. So if I'll give a completely hypothetical. The Dolphins are favored to beat somebody by 30 points. That's completely hypothetical. I can't imagine a team that they would ever.
I get the sarcasm is duly noted.
But let's say the Dolphins are favored to beat New England Patriots by 30 points. And
Brady's not going to play the first.
And then you find out, maybe, but you find out then about several injuries that weren't reported. the Dolphins.
Yeah, no,
then
your
it's a spread,
point
and it makes-
absolutely is well taken.
It's much
because,
more analytical.
Because when you involve a team sport, there are aspects of the team sport who wins or loses. There's so many variables.
Think of all the class actions Pete Rose would have filed if he had known about injuries that weren't available because of his sports betting habit. But anyway,
No, but I think ultimately you got to draw the line because if the consumer expectation, right? So that's why I think, to me, the strongest foot here are the gamblers, are the folks that that participate in that where it's legal in Vegas.
yeah, but the gamblers are going to have a tough situation because it's not like there's a point spread. I guess the people who bet for Pacquiao would claim that they would not have bet. They would have either not bet at all, or they would have bet for Mayweather had they known about the injury.
Absolutely, and remember, their damage or their commitment to put in the money was not the only thing they cared about was winning. It wasn't about going to Vegas. It wasn't about the experience. It's not about, they weren't paying for the event. They were paying for the result. They were hedging their bet on. It's kind of like the stock market analogy. Maybe that's a bet. If a company's going to go public and they don't disclose a material fact that would dictate whether or not you're going to invest in that company or buy stock in that company or sell, right? That's important. I mean, that would be the analogy, because those people are directly affected by that, as opposed to a consumer that goes to Target and it's about the experience. They're not necessarily a stockholder. So the outcome of the fluctuation of the price is not going to be as big of a deal. But anyways, listen, we can talk about this for hours.
Right.
Unfortunately, we don't have hours. We've just been told we have 2 minutes.
Ooh.
So a grand old 2 minutes. So I think, look, the last 2 minutes of the show, I think one of the things that I wanted to get to real quick is what the show is, and it is not. So I had here, it's entertainment over informative. Okay? It is humor over facts. It is jokes over plugs, and I don't mean the hair plugs. I mean the actual plugs of... I'm sorry, did I actually point at you? It just, we want to keep it on the light side, being informative, but above all, have fun with it.
Right.
And I tell you all the time, it's just two guys, regular guys you can have a beer or a scotch with, talk about law, talk about anything else. Or both.
Yeah.
So the 10-second takeaway, please.
10 seconds, wow. I think
Since I
that
filibustered the last 2 minutes.
The Pacquiao class action is going to open up a potential can of worms, and I think they're going to have a hard time succeeding.
That's very good. That was actually in like 11 or 12 seconds. So if we can actually get the last slide up for those of you watching online, so you can have the benefit of these words of wisdom. This came from Benjamin Franklin. And he succinctly said, by failing to prepare, you are preparing to fail. So, Neil, you're not going to stop us with these words
you told
of
me
wisdom?
that I interrupt your quote, so I'm just going to let that one sink in.
Excellent. So make sure you prepare. And Neil, the next time, please, the Wikipedia, I think, worked out excellent today. And Miguel, thanks for calling.
Oh, boy. Yeah, thank you, Miguel.
Tune in again next week to Attorney Confidential with Gus and Neil.
Right, good evening.
You have been listening to Attorney Confidential with Gus Bravo and Neil Kotze, two rated AV trial attorneys with over 40 years of experience. Tune in next week for another episode of entertainment, insight, and just plain fun. That's Monday, 6 p.m. on WNN, 1470 AM. See you next Monday for more Attorney Confidential. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.